Call the third case on this morning's docket, case number 117747, State of Kansas v. Marvin L. Gray.
Marvin Gray appears through counsel Michelle Davis, and may I please reserve 2 minutes for rebuttal?
2 minutes is granted.
So this is a case where Mr. Gray and the victim had been longtime acquaintances. They had been out shopping that evening, and according to Mr. Gray, then he was at her house in the early morning hours and they had consensual sex. That afternoon, her boyfriend finds her deceased in her house and calls the police. And so this is a case that weren't any eyewitnesses. It was based on circumstantial evidence. And that the state convicted Mr. Gray of premeditated murder, rape, and aggravated burglary, which is the entering into the house with the intent to commit the sexually motivated crime. And we raised several issues in our brief. First, the identical offense doctrine, which primarily relates to the sentence. And then the erroneous admission of 6455 evidence, and then also the failure to give an instruction on intentional second-degree murder. So basically, it's our contention that this court last looked at, not last, but the leading case on the identical offense claim is Warlado from 2008, and that changes in the law since that time weren't revisiting that issue.
Before you get there, can we talk about preservation just for a moment?
Sure.
And you acknowledge this was not argued at the district court, even though there was opportunity to do so.
Yes.
Either at the time of jury instruction, at the time of post-conviction, and especially at sentencing. This could have been brought up because essentially that's your issue, is that he can only be sentenced for a second-degree murder, correct? So
Yes.
There's opportunity to bring this up, and why should we take this up at this point in time, at this juncture?
Well, as we set forth in our brief, this is purely a legal issue, and is a purely illegal issue.
That is determinative of the case. How is
Yes.
this determinative of the case?
Well, basically, it will settle the issue, but it's strictly a legal question. And you're comparing the elements of the crimes. And so, therefore, that warrants review. And then also the statute 216820, which says that this court has jurisdiction to review an error in making the
So
severity.
finally determinative of the issue is the same as finally determinative of the case?
Well, in terms of this claim, absolutely, in terms of a sentence. So basically, what the identical offense doctrine, why this issue is now different from Warlado is that with McLenn's decision that premeditation is a temporal consideration about when the intent to kill is formed, that basically defining premeditation as forming the intent beforehand doesn't distinguish, because second degree intentional also requires that you form the thought beforehand. If you look at the jury instructions in this
Can't
case,
second degree, we never held that second degree can't be. The intent isn't instantaneous with the crime. Isn't that the difference here?
well, it was at the time, and that's been that way for 30 years. I mean, this court inherited those
Well, how did
concepts.
McLenn change that?
Well, not just McLenn, but if you look at the jury instruction, second-degree murder with the recodification in 2011, second-degree murder now requires the state to prove thought beforehand. And it didn't before 2011. If you look at the jury instruction, it says you act intentionally. A defendant acts intentionally when it's the desire or conscious objective to cause the result. That requires thought beforehand. If you look at the definition of knowingly, it's that you're aware of the conduct is reasonably certain to cause the result. That requires thought beforehand. Prior to 2011, all you had general criminal intent. And you proved that general criminal intent by either intentional or reckless conduct. And as this court's aware, we gave the jury instruction that says a person is presumed, it's presumed that a person intends the usual consequences of their voluntary act. So really all the state had to prove was intentional conduct. And then you had the inference, the presumption of intent. And the classic example of that is a defendant that says, sure, I shot in the direction of that person, but I wasn't trying to kill them. That didn't matter, because all the state had to show is intentional conduct, and then they were given the jury instruction that says you intend the usual consequences of your voluntary acts. That's it. Now, specifically, the legislature has overridden that. We don't give that presumption of intent instruction anymore. Because when the legislature recodified the code in 2011, The legislature now defines intentionally. It defines the mental states that the state specifically has to prove. At the time of Warlado, and that 30 years ago when we said premeditation was stopped beforehand, that really did mean something. It's because with premeditation, the state specifically had to prove that for first-degree murder. The state didn't have to prove it for second-degree murder. All they had to prove was intentional conduct. So now with the jury being told, you have to show that specifically the state has to prove that the defendant had a conscious objective to cause the result, which is the intentional killing. A defendant has to think about it beforehand. Therefore,
Your position is that the conscious objective to cause the result can't be made instantaneous with
that's correct.
And why is that?
Because instantaneous intent is a 30-year-old concept. It came about at the same time that this language that this court inherited about thought beforehand. And at that time, the only way I can really understand instantaneous intent is this concept of intentional conduct, and you infer the intent from the intentional conduct. From shooting in the direction of somebody, we're going to infer that somewhere there had to be this instantaneous intent. It doesn't work. Instantaneous intent as a concept doesn't work with the legislative definition of intentionally.
But it's
That
still,
concept doesn't work.
it's still our definition of premeditation, isn't it? I'm looking at PIC 54-150 homicide definitions. Premeditation means to have thought the matter over beforehand. In other words, to have formed a design or intent to kill before the act.
Right,
No specific time required. The concept of premeditation requires more
right,
than the instantaneous intentional taking of another's life.
right.
That's different than the definition of intentional.
Well, no.
It requires more, doesn't it?
No, it doesn't, because if you keep reading and what the definition of intentional is, that's the same thing. It's intentional. If you have a desire, conscious objective to cause the result, you've got to have thought beforehand. You've got to have thought the matter over beforehand. And there is no instantaneous intentional act anymore. If you look at the definition of intentional, you can't act intentionally and instantaneously. It doesn't work. Because if you're going to have the desire or conscious objective to kill somebody, that can't be an instantaneous intent. You've got to have thought about it beforehand. You have to have the intent before the action.
So being conscious and premeditating are the same thing?
The way this court has defined premeditation, yes. Because in the past, it was inferred that there was some sort of reflection that was required for premeditation. And that's not true anymore. So basically, the matter of whether you convict somebody of first-degree murder or second-degree murder is totally at the whim of a jury. I mean, basically, any sort of intentional killing can be prosecuted as premeditated murder. And if the judge will instruct on it and the jury will consider it, then the jury can go with second, but that's all it is. It's really kind of a discretionary decision, because every intentional killing can be a premeditated killing the way it's defined. So basically, that's the crux of our argument, and that because of that, the identical offense doctrine is based on due process. It's based on constitutional considerations. So it just as a matter of due process, that because the conduct, there are two identical offenses here that cover the conduct, that Mr. Gray should be subject to the penalties for the lesser offense. And that's why we think this court should revisit that issue, because of the changes in the way that second-degree intentional murder is now defined and the changes in the way that this court is defining premeditation.
And that would just wipe the premeditated murder statute off the books, right? Practically speaking, that's the
Or
impact.
force the legislature to tell us what premeditation is. I mean, it used to be that when you had first-degree murder, it had to be done with malice, it had to be done with deliberation, and first-degree murder meant something. They took malice away, they took deliberation away, and they beefed up second-degree intentional. But when they beefed up second-degree intentional and said the state has to explicitly prove this, they didn't then tell us, well, what do you want for premeditation then? So, I mean, it needs to mean something. Premeditation has to mean something. You're saying we have an enhanced penalty here. And, it doesn't make any sense if you're going to say, well, if you kill somebody quickly, if you fire one shot, then you can get a second-degree intentional instruction, and then the jury at least has some kind of choice here. But if it takes 3 shots to shoot somebody, or you kill them a little slower, sorry, you're going to get the hard 50. So what warrants mitigation in the current state of the law? The current state of the law is if you shoot somebody quickly or kill somebody quickly, you might be able to get a lesser offense. That's basically where we're at. And that makes no sense whatsoever. And the legislature now says that premeditation is a hard 50 cents. It used to be, it was 25. They've beefed it up to hard 50. So if it's going to be hard 50, then it should mean something. And then I think on the other issues, the brief pretty much sets those through. I don't think that I really have anything to add to those, unless there are questions from the court.
Do we have any more questions? Thank you, counsel.
Thank you.
May it please the court, Assistant District Attorney Leslie Isherwood appearing on behalf of the state. The first issue before the court today, the defendant challenges the identical offense doctrine and that he should have received a sentence more in line with second-degree intentional murder as opposed to the hard 50 sentence that he received for the premeditated crime. It does present a question of law over which this court exercises unlimited review, and as noted in our brief, this precise issue was decided adversely against him in Warlido because the identical offense doctrine does not encompass crimes that are of different severity levels but the same offense. And that is essentially the approach that this court has taken over time with the justification that the legislature has identified that hierarchy of crimes by setting out the aggravated characteristics to denote which crimes are more serious or which are the greater offenses. What the defendant is attempting to accomplish here today is to draw a bright line rule where one simply does not and cannot be established. It has never been the position of this court or the legislature that intentional killing was akin to an involuntary reaction where there was no thought process at all. Obviously, it's an intentional act. The distinguishing characteristic between the premeditation and the intentional act is the forming that design and the planning that goes into that determination to commit the murder. There's a distinctly different time frame, but it is not one that's conducive to the bright line rule that the defendant is asking this court to establish here today. Even if this court were to pursue some sort of identical offense analysis, it simply does not work with this case. The defendant was charged with a premeditated killing, and that's what the state was required to prove. In order for the identical offense doctrine to come down favorably to the defendant, you would have to have two crimes under which he could be prosecuted, and that simply was not this case. The state would respectfully request that the
Explain that to me again.
Two offenses under which he could be prosecuted. They would have to be identical in their elements in their application, that he could be prosecuted under either one, and that's not the case here because of that premeditated element that has to exist.
The defense suggests that if we look below the names that we give these elements, they are identical.
Because,
so don't you have to respond substantively as opposed to just saying, well, we have premeditation here?
Well, because I think he's attempting to equate all intentional acts with premeditated, and that simply isn't the case.
But why isn't it the case?
Because there are those cases like here where there is a well thought out process and a design with an intent to kill that is more than just an immediate or instantaneous reaction as we have understood intentional to be.
But isn't our identical offense doctrine purely a question of law based on the elements of the crime? We don't look at the facts of the case.
It exists in three scenarios. It's overlap of elements, but it's also one of the inquiries has been lesser included offenses, and this court has consistently held that the identical offense doctrine does not apply in the situation where you're looking at lesser included offenses, and that's what we have.
I guess I'm just simply asking you to respond to the argument that the elements are identical.
But, okay, so they aren't identical because there's the premeditation element. Is there an intentional killing? Yes, and that
Let
would
me
be
ask it this way. Is there any difference between the intent required for a second-degree murder conviction and the intent required for a premeditated conviction?
Yes, and it's the period of time. A premeditated murder requires a more extensive or in-depth thought process than an instantaneous killing. So
You
it's
can prosecute an instantaneous killing under the second-degree murder statute.
But you
and
cannot prosecute-
Cannot under the first.
correct.
You may have said the opposite a moment ago. That might be the source of some
And
confusion.
just one last follow-up, your opposing counsel has suggested to us that there's no such thing as instantaneous intent.
Because I think she's trying to equate instantaneous with what I would say is an involuntary reaction. She's saying that instantaneous requires no thought process at all, and I don't think that's necessarily the case. You can have an instantaneous killing without having a premeditated killing. And
How do
I
we
think-
tell the difference between the definition of intent that's applicable to second-degree murder and premeditation?
Because you look at, well, again, there cannot be a bright line in the time that's required. You can look at the design and the thought process of the defendant as established by the circumstantial evidence to determine exactly how meticulous they were in planning that killing versus an instantaneous
Is there any
killing.
standard that's objectively understandable that we can give to juries so that they can differentiate between premeditation and plain old intent under the statute?
Well, and we've been cautioned not to try and go too specific in how we describe premeditation to the jury, but then that's where you go into the circumstantial evidence of premeditation and you look at the evidence surrounding their conduct, and that helps explain the premeditation component in their design of an intent to kill versus an instantaneous act.
I think this court has held that evidence can establish premeditation very, very close in time to the actual killing. It just simply has to be beforehand.
Yes, but this court has equally cautioned that we are not to tell the jury that premeditation can happen in an instant.
And there's a distinction too between the act that causes the death and the act that, Justice Johnson's old dissent about the difference between the act that causes the death and the beginning of the potentially fatal behavior. This is where we get the intention formed during a strangling, for example. This case isn't really a good poster child for it could have only been premeditated, is it? Because you've got the kind of, extreme violence. The dozens of stab wounds could be kind of a frenzied act or a long torture. We really don't know, do we?
Well, and I did want to kind of segue then into the third issue with respect to the instruction, and I realize that counsel did not address that during their opening argument, and so I have no issues with addressing it on rebuttal. But so as far as that, whether a jury would have been properly instructed with respect to first-degree murder, and that would be a clear error review of that issue in this case because the instruction was not requested. So that would require this court to look at whether it's legally and factually appropriate to determine whether error did occur, and if there was error, is this court firmly convinced that the jury would have returned a verdict for that lesser crime if the instruction had been given. Now, given the nature of these offenses, the argument here begins with whether it was factually appropriate. And the evidence strongly established that the defendant strangled, stabbed, and then left CR face down in a bathtub of water. And utilizing the factors that this court has looked to determine whether premeditation can be identified in a case, we look at first the nature of the weapon used. And in this case, the defendant essentially used 3 different weapons. He strangled her, he stabbed her 37 times in the torso alone, and then left her face down in the water. A lack of provocation. There were no defensive wounds to the victim, and there's no evidence of any sort of altercation initiated by the victim. The defendant's conduct before and after the killing, and I think this starts one of the critical factors. The defendant engaged in surreptitious behavior in even getting to her residence. He left to get to her residence during the early morning hours and then took, by his own words, darkened back streets so that no one would see him getting there. Now, his explanation was because he was either on probation or parole and he was under the influence and didn't want to be apprehended. Then he broke into her residence. Then after the crime is committed, he attempts to conceal the fact that he was in her residence by conducting an extensive cleanup to eradicate all evidence of his DNA. And then he leaves and attempts to conceal his exit of the residence by leaving during the early morning hours. And then disposing of the murder weapon and any clothes worn with respect during the course of the crime. And then gave 3 different evolving stories to detectives as the case was investigated. So all indications were that he attempted to distance himself significantly from the scene. The dealing of lethal blows after the deceased was felled and rendered helpless. The evidence from the pathologist indicated that the strangulation or the asphyxiation did not kill CR, and that was evident by the fact that her blood continued pumping after the stab wounds occurred, and that the way that those stab wounds presented indicated that she did not put up a struggle or was otherwise mobile during the course of that attack. So that tells us that the defendant, after engaging in one violent act that this court has identified as evidence of premeditation, which was strangulation, the defendant then engaged in another violent act, which this court has found to be evidence of premeditation, which was dealing several lethal blows after she was helpless, and then if that was not enough, leaving her face down in the bathwater. Even if this court were to find that there was error in not giving the instruction, it has to be firmly convinced that the jury would have returned a different verdict had the instruction been given. It is not could, it's not was there a possibility, it's would they have returned a different verdict, which expresses some sort of inclination to do so. And it's not that this court thinks, yeah, maybe. It's that this court thinks that this case is the one where this was an instantaneous killing that the jury would have found as such and returned a verdict for. For those reasons, the state would argue that this was not clear error in the absence of this instruction. If there are no further questions from the court, the state would respectfully request that the defendant's convictions and the decisions of the district court be affirmed.
Do we have any further questions? Thank you, counsel.
I think I'd just like to point out that if we're having this much trouble figuring out what distinguishes the intentional definition in the jury instruction from the premeditation definition in the jury instruction, how does that provide a standard for a jury to use? And again, the identical offense doctrine is based on due process considerations. So without some sort of clear standard, how are non-lawyer people going to make these sort of judgments? That concludes my comments.
Do we have any more questions? Thank you, counsel.
Thank you.
Thank you both for your arguments this morning. Court will take this matter under advisement.